Thank you so much. Thank you, Patty, and thank you all for being here. It's an honor for me to present this project to you. So the presentation will cover several different projects that are all about the rise of Nevada as a liability-free jurisdiction. And I will cover three main arguments here. The first is that over a decade ago, Nevada has embarked on a calculated strategy to offer almost no liability corporate law in order to attract corporations and increase revenues. The second is that Nevada's strategy has been successful because by doing that, Nevada has segmented the market and left Delaware, the state that attracts most of the corporations in the country, with no ability to respond. And the third part will discuss a co-authored work with David Smith from our McIntyre School, where we look at the companies that incorporate in Nevada, and we show that they have a significantly higher frequency of accounting restatements than corporations incorporated in other states. So more frequently, they go back to the market in order to amend their previously reported earnings. So before I start, I want to give you some background. So the US system is unique in that it allows corporations to choose where to incorporate regardless of where they conduct their businesses. And you have probably heard that most of the corporations go to Delaware. That's true. But what does that mean? By choosing Delaware, corporations really choose to be governed by Delaware law, by Delaware corporate law. And they pay some fees, incorporation fees, for Delaware law and its legal system. And indeed, as a result of so many corporations going there, Delaware law governs most of the corporations. This is the law that we teach in our textbook, in our corporations courses. This is the law that most national law firms are working with. That's Delaware law. Now, one would think that in this kind of system, a market would emerge where states compete to attract corporations for disincorporation fees. Indeed, Delaware derives significant profits from disincorporation business. But if there was competition, a consensus has emerged that it has ended a while ago. It has ended because Delaware has won. So in two important papers, scholars have shown that other states do not compete with Delaware, do not make attempts to compete with Delaware. The Delaware market power is so significant that other states face significant barriers to entry. The Delaware has advantages that are difficult to replicate because so many corporations are already incorporated in Delaware. Delaware has a developed body of case law that other states do not have. It has a specialized judiciary that understands corporate law. And therefore, it's going to be very difficult for another state to try to attract corporations from Delaware. In addition, even if another state tries, Delaware can always respond to that by changing its law, changing its price. And as a result, states are not even trying. And even Nevada, that has made some attempt in the past, is really not making any profits from incorporations and merely is following Delaware law. While that has been true, in the last decade, something has changed. In the last decade, Nevada has increased the price that it charges for incorporations significantly. And despite the increase in the price, it also increased its market power, its market share. It attracts a larger share of the market now, and has increased its revenues from several thousands to several millions. So how did this happen? How did Nevada enter the market? How it increased revenues? How it increased price and nevertheless increased market share? What happened? So apparently, in 2001, Nevada has made a significant legal change. And the change was directed to provide directors and officers with broad protection from liability. much more than what's offered them under Delaware law. So while in Delaware, as we all teach, directors and officers are liable for breaches of duty of loyalty, breaches of duty of good faith, sometimes also breach of duty of care. In Nevada, most of this exposure has been canceled. And directors and officers are protected by default from lawsuits based on breach of their duty of loyalty, breach of the duty of good faith, and breach of the duty of care. They remain liable only for a quite narrow category of conducts that amount to intentional misconduct or knowing violation of law. So you can see that while in Delaware, directors and officers face liability for all of these categories, in Nevada, it's really only the first category for which directors and officers can be liable. They're protected from all of the rest. Now, remember that corporations can choose where to incorporate. So what that means is that now there is an option for corporations to be governed by almost no liability regime. So this is the first finding, and in addition to that, Nevada has also applied high deference to directors and officers when they defend against hostile takeovers. So if you ever heard about Revlon duties or Blasius or Unicol duties in Delaware, they do not apply in Nevada. In Nevada, directors enjoy the business judgment rule also in this situation. So a very significant difference from Delaware law. So what does that mean? First, what does that mean for Nevada? So this project argues that this strategy has been successful for Nevada for several reasons. One of them is that by doing that, Nevada has segmented the market. It's offering law that is not available under Delaware to a subset of companies that have a strong preference for protection from liability, that are not being satisfied with Delaware law. As a result of that, it gains market power toward these companies. And this is why it can charge a high price from these companies. So, let's look into it. Yes?
So, there are 49 other states in Delaware, and Nevada is the only one that's tried this strategy? None before Nevada?
Right. So that's a great question. So why is only Nevada trying this strategy and not other states, right? I'll offer one reason. I don't think that explains all of that, and I think other states may try coming later. But I think that Nevada has a unique competitive advantage in offering this strategy, which is that Nevada has offered lax law in many other fields, right? And Nevada reputation helps Nevada, right, in that aspect, because it is better positioned to create a credible commitment for management that they're going to continue, right? They're going to be consistent with sticking to this law and not changing it in favor of shareholders, right? And this is one of the reasons why it also helped Nevada enter this market. More questions? Okay, great. So let's look a little bit into these details of Nevada's strategy. So the first is Nevada is offering a different product than Delaware, and legislative history here suggests that there was a clear awareness and intention to differentiate themselves from Delaware. So here in 2001, on the floor, a local lawyer, Michael J. Bonner, explains to the representatives that if Nevada offers a law that is similar to Delaware law, there's no way they're going to attract corporations from Delaware. Delaware is going to be the default, and the only way to attract corporations is by offering more protection from liability than what Delaware offers. Right. So a clear intention to offer a different product than Delaware. In addition, so there was also opposition, of course. Opponents have pointed to the potential risk of attracting particular type of corporations, right? It's going to protect corporate crooks. It's going to become the hole in the wall. It's going to, I like the third one especially because it suggests that there could be a self-selection here, right? It's going to attract scoundrels. And this is an argument that David and I focused on in our project on restatement. Does it really attract problematic kind of companies? So there were concerns, and these concerns were pronounced, but despite the concerns, the law was passed, partly because the opponents were promised that the revenue, the money that is going to be raised from incorporation fees will be used to increase teachers' salaries. So they eventually voted in favor of it. Okay, so again, clear our intention to offer a different product despite concerns. That's the only strategy that can work. Nevada has also adopted a marketing strategy that focuses on these differences. Nevada has positioned itself in the market as the producer of no-liability regime. So from the website of the Secretary of State of Nevada, right, highlighting differences between liability in Delaware and liability in Nevada as a reason to incorporate in Nevada. Why you should come to Nevada, that's the Secretary of State website, because directors here are more immune, because Delaware status does not protect officers, because under Delaware, you can be liable for breach of duty of loyalty even if you did not conduct intentional misconduct or not in violation of law, and not here, because Nevada gives you more deference in your decision. Another aspect of market segmentation strategy, Nevada has positioned itself in the market as a player who offers a different product and stresses these differences. Yes?
Did you look at the origin of this? Was there a strong business lobby that was proposing this?
Yeah.
Where did it start?
Right. There was a business lobby in Nevada that for a while was trying to attract corporations and to establish a business court, not always in a successful way. I do not have a good answer to why it suddenly succeeded. Yes. But it's a very interesting question. More questions? Great. Yes?
So Delaware is a place, Nevada is a place where all the corporate counsels go to protect it. Has there been any movement on the part of the investing community to be concerned about corporations that reincorporate within our Nevada corporation because of the self-selection that you're describing?
Great. I'll get to that later, but I'll just say shortly that while we see that corporations that go to Delaware benefit some premium from choosing Delaware, we don't see the same premium in Nevada. At the same time, there's no discount for incorporating Nevada relative to other states. And I'll talk later about what that means. Okay, great. So market segmentation helps Nevada to make profits. But then you may ask yourself, then why with lax law? We could also segment the market with offering a law that is protective to shareholders, right? Maybe more protective than Delaware law. Why not that? Why lax law is the strategy that has been successful? And indeed, North Dakota has tried offering protective law to shareholders, trying to maybe segment the market with the other option on the spectrum. And that was not successful. North Dakota is not successful in attracting companies. Shareholders vote against reincorporation to North Dakota. So why lax law? So I think lax law has several other advantages from Nevada perspective, not from social perspective, but from Nevada perspective. First, lax law is very clear. And because it's very clear, it undermines Delaware advantages. It's less important that Nevada does not have a rich body of case law. It's less important that Nevada does not have specialized judiciary because the law is so clear, right? There's no liability. You don't need judicial discretion in order to apply it, right? So that's one reason why this lax law undermines Delaware advantage. And the other is related to my reply to George, right? Nevada has a clear competitive advantage here, certainly relative to Delaware. Nevada history of offering lax law helps the state to create a credible commitment for laxity that Delaware cannot. And the other reason is that this is maybe the only strategy that Delaware cannot respond to. Because in order to respond to that strategy, Delaware would have to degrade its law to protect managers more. And Delaware has many reasons not to do that. One reason is that may trigger federal intervention in corporate law that could basically take Delaware business away, right? The sweeping federalization of corporate law would take Delaware business away. And if Delaware becomes too protective to managers, that may increase the likelihood of that to happen. Another is that may harm Delaware brand. It's not consistent with Delaware cases. And there are several other reasons that I'll be happy to discuss later. One of them is that Delaware officials have told me in conversation said, we may not be interested in attracting all of the companies. We want to attract the good companies, the better companies in the market. And indeed, as I said, North Dakota has tried the other option, which did not work, offering more protective law to shareholders. That's another question, why it hasn't worked at all, why not some companies are going there. And I think the answer to that is that the package that Delaware offers, including all of its advantages, is so superior that even if you offer a law that is somewhat better for shareholders, it's hard to match this package given all of other Delaware advantages. So Delaware covers this range of companies that are interested in law that is somewhere between the top and lower than that, and Nevada targets the lower part of the market, the bottom part of the market. Yes? Great, yes. The answer is the internal at first doctrine. The internal at first doctrine is a doctrine that all states follow, or almost all states follow. There were few exceptions, but they were really narrow. And under this doctrine, the law of the corporation applies according to the state of incorporation. So by choosing the state of incorporation, you choose corporate law regardless of where you conduct your business. So if you are incorporated in Delaware, courts in other states would apply Delaware. If you are incorporated in Nevada, courts in other states would apply Nevada. And states follow that quite consistently. And that's really unique to corporate law. It doesn't apply to other rules that sometimes regulate corporations, but only to corporate law. More questions? Okay, great. So that's for Nevada, right? But the question is also, so we understand why Nevada has adopted this strategy, why this strategy has been so successful, right? But is it good or is it bad? Or what does it mean for our system, right? So in order to answer this question, we have to look into the companies that go to Nevada. And we have to see what kind of companies they are. Is it true that it could be companies that are trying to take advantage of Nevada law as the legislative history suggests, right? Or do they go for other reasons? So the first question is, where do the Nevada companies come from? So Nevada companies come from all over the country. You don't see it here. That answers a distant question. But there's another table that we have that shows that Nevada companies come from all over the country. But they tend not to come or to come less from states that already offer them strong protection. So these 5 states are known for offering strong protection for management. And you can see that the proportion of companies in Nevada that come from these 5 states is only 5% in total. So only 5% of the companies in Nevada are either from Massachusetts, Pennsylvania, Virginia, Maryland, or Ohio. In Delaware, in comparison, 15% of the companies are from these states. So we see that companies that come to Nevada come from states that don't offer them protection. Companies that come to Nevada are very sensitive to the question we offer protection in our states or not? Companies that go to Delaware are not that sensitive to that question. So we're looking at a different kind of companies with a clear preference for protective law, for a law that protects them. And again, this is not true to the same extent about companies that choose Delaware. And here there's another indication that the companies that go to Nevada have high preference to protection. On an individual basis, on a per firm basis, these companies opt for more protection in their charter, bylaw, and contracts. More protective clauses and more indemnification clauses for directors in case of lawsuits than companies in other states, than companies in Delaware, right? So the ratio of indemnification contracts in Nevada is more than 30%. In Delaware, it's 7.5%, right? So on a firm-by-firm basis, beyond the protection of the law, companies that go to Nevada also adopt more and more layers of protection. So we're looking at different kinds of companies with high preference for protection. This also supports the market segmentation argument, right? Nevada is targeting a segment here, a segment in the market with high preference for its product, with high preference for protection, right? But then the question is this good or bad? And I think there are at least two potential accounts. One is it is bad because of what the legislative history suggested, right? These are companies with maybe high agency costs, high private benefits, and they're going there in order to take advantage of Nevada companies. And the other explanation is these are companies that maybe need less the protection of the law. Maybe they have better internal controls, and they don't want to be exposed to lawsuits, sometimes frivolous lawsuits in Delaware, and this is why they go to Nevada. So in the project with David Smith from McIntyre, we're trying to look a little bit more into this question of who are these companies by looking at companies' accounting restatements. So, or looking at the quality of disclosure to the market. Right? So but why accounting restatements? So accounting restatements happen when management go back to the market and tell them, what we reported to you in the past that we did, when we said that we did so well, we actually did it, and we have to change it. And not surprisingly, in most cases, the market do not like that. There's a negative price response in the market. There's evidence that managers' credibility is being harmed by restatements. Restatements are correlated with other negative measures of corporate governance. And several legal scholars have suggested that restatement may be a way to scheme value for management, a manifestation of agency costs. And in support of that, there's evidence that restatements are correlated with equity-based compensation. So when managers are compensated with equity-based compensation, they benefit more from reporting that they did well because the compensation is more sensitive to how the company did. And there is evidence that restatements are more frequent, and this kind of compensation suggests that there's something in restatement that sometimes helps management to scheme value. Questions? Now, of course, not all restatements are like that. We also focus on different kinds of restatements that are more problematic, those that involve either fraud or that trigger a regulatory investigation. And the findings here are quite striking. As you can see, the blue line is restatements in Nevada. The green line is Delaware, and the last line is other states. So significantly higher frequency over the entire sample period of restatements in Nevada. We find that the frequency of restating in Nevada is double than in Delaware and other states. After we control for differences between Nevada companies and other states' company, we find, that the restatement frequency is 40% higher than in other states. We also, as I said, focus on restatements that involve fraud or trigger regulatory investigation. And also there we find a significantly higher frequency in Nevada companies. We also create a match sample of similar companies in Nevada and Delaware and find the similar differences. We also look at a metric that was created by Audit Integrity. It's a company that ranks companies according to their reporting and how aggressive they are. And also under the metric, Nevada companies are coming as much more aggressive from accounting perspective than other companies. Yes? Great. So we control for industry, and the differences remain significant after we control for industry. Now that's an interesting question. Is there a concentration of industry in companies in Nevada? And there is some. We find that there are more companies from mining and oil industry in Nevada than in other states. But it's not that significant. And when we control for these differences, we still have the significant differences in accounting statements. Yes? Right. Right. Great. I'm sorry? Right. Yes. No, that's a great question. So we have one limitation here that our sample starts only in 2000. So the only analytics number starts in 2000. 2001 was the legislative change, and 2002 Sarbanes-Oxley. Both probably could affect the restatement, but we don't have enough data before that in order to do that. We also try to look at companies before they incorporate in Nevada and after they incorporate in Nevada. The problem is that most companies decide on the stage of incorporation at the IPO stage, so we didn't have much before and after, not enough in order to get to any results. Yes? Great. Great. So there has been some research that was done on this spike in restatement literature in general. And what seems to be the best explanation for that is that this is as a result of Sarbanes that was regulated in 2002. And this is really a cleanup that companies do because of Sarbanes and had to restate. So there's one study that shows that most of these restatements in the spike amend reporting that was done prior to Sarbanes. So, and also here, what's important for us is that on every period, in every aspect, Nevada is higher. Yes?
So what year did you say that the law went into effect?
2001.
So most of the spikes we see in the statements that happened before 2000?
No, I'm sorry. Here I was referring to
2005, 2006 spikes, and most of which we see is before Sarbanes.
before Sarbanes was 2012. I think you were referring to the Nevada law. Yes.
So was it, but I guess my question is, were they restating, your theories would suggest that they should be restating fraud or near fraud after the Nevada law went into effect. So, but you also told me that they're restating things that went in before Sarbanes-Oxley.
Yeah.
There is, I guess, a 1 year old there.
No, not at all. Yeah, first, I don't think that the Nevada law affects the level of restatements. I think that Nevada law affects the kind of companies that do it. So whether or not they had to comply with Sarbanes, that's a different question. But it's the type of companies that are attracted to Nevada. So we don't think that Nevada law, we actually try to look at that. We don't find any evidence for causation. It's only a self-collection story. And the other is that I'm not that interested in the spike. I'm interested in the fact that this difference remains through the whole period. So this, because the spike has happened to both of them in a way. Yes?
In an earlier generation from 1960 and earlier, Nevada had a reputation to be a home of organized crime. Hotels, casinos were owned by people who FBI was after. And Nevada's businesses were illegal in the other
Yeah, you know, I can't really answer that because I didn't do research beyond this choice of law. But there are Reuters journalists who are doing some research on criminals that go to Nevada now and try to use shell companies in order to merge into them. And they, as part of, in response to the research, the Secretary of State now has established a special committee that is trying to look to find fraud or criminal activity, right? But this project doesn't focus on that because Nevada, even here, still prohibits, right, knowing violation of law. So we're not talking about fraud, but we're talking about many other things that are not allowed in Delaware, or at least are scrutinized heavily in Delaware, like self-dealing with a company, and are not as scrutinized in Nevada. But just, a Nevada lawyer sent me this. That's from The Onion from 2002. So in 2001 was the legislative change, right? And The Onion have this in 2002 saying that Nevada law is just choosing to go completely, to cancel all of its law, to go lawless, right? But as I said before, I think that actually really helps Nevada in this, and that it really supports its strategy for these companies that are interested in strong protection. Nevada is probably the best choice. Yes?
You said it's a self-selection story. What effect does that have on the social cost?
Great. Yeah. Yeah.
Unless there's some independent effect that will last long.
Yeah. Great. So I'm going to get to it very soon, okay? In a minute. So first to the question of, we found restatement, but what about Nevada valuation, right? This is the question that was right here. How investors price that. As I said before, what we find is the following. And here I want to be careful because I have to say that valuation studies are complicated. We on purpose did not focus on that as our main measure. The value of companies fluctuates a lot, especially of small companies. So you have to take it with a grain of salt. But what we did find is that, as I said, Delaware companies, in a famous study, Rob Daines is showing that Delaware companies have premium over the market. Delaware companies are being traded in a higher value than companies in Delaware, and that's reflected in the Tobin skew. Tobin skew basically is the ratio between the value of the company in the market and its assets. So the idea is that if Delaware law is better than Nevada law, right, or other states' law, then the same asset should be traded in a higher value, and that's reflected in the Tobin. The same machines, the same cars, when they're governed by a better law, they should be traded in a higher value. And indeed, the Delaware law, there are firms that have higher Tobin Q, higher value per asset. So what we find is that Nevada companies do not have this premium. So if you compare them only to Delaware law, they have a discount relative to Delaware. But if you compare them to all of the other states' law, then they do not have a discount. They are being traded similar to how corporations in other states are being traded. So what does that suggest to us? So what does this suggest to us? So there is another important finding in addition to that, which is that if companies restate in Nevada, then the market penalty that they get is much stronger than if they restate in Delaware, for example. So overall, they're being traded with no discount. But if you do something bad in Nevada, then you're being penalized much more than if you did it in other states. So we think that one possible explanation, but it's not necessarily the only explanation, we didn't rule out other explanation. One possible explanation that is consistent with that is that there's a mix of companies that is going to Nevada. Some of them go in order to take advantage of the law, but not all of them. Some of them go because Nevada charges are effectively somewhat lower than Delaware, higher than other states, but lower than Delaware. Some of them go because maybe it's efficient for them to go. Maybe for some companies it is efficient not to face these laws because they have strong controls or because of other reasons. So the mere signal of incorporating in Nevada is a mixed signal. Investors don't know yet how to do it. But once you restate in Nevada, investors respond not only to the restatement, they also respond to it as a message of information, as a signal. For them, now the likelihood that you are the type of company that went to Nevada for the wrong reasons is higher. Now it's more likely that you belong to this problematic group of companies that went to Nevada in order to take advantage of the law. And this is why you are being penalized more when you restate in Nevada than when you restate in Delaware. So that's one potential explanation. There's another explanation. Lucian Betrick and Alma Cohen has just shown in an interesting paper that there is what's called learning corporate governance. It takes time for the market to learn. So maybe investors don't know yet enough about Nevada companies. We don't know. We're just offering potential explanations to why that could be. Right. Any questions? Yes. I didn't answer your questions yet. Right. Great. Excellent. So now let's get to the policy implications. Right. So what are the policy implications? So first, in this literature, there used to be a debate on whether or not this system creates a race to the bottom or a race to the top. Is it that this system where you can choose your state of incorporation encourages states to produce good corporate law and they race to the top, and therefore it's a good system, or what Roberto Romano has titled as the genius of American corporate law is that we have this system, or is it a system that some have argued results in rules that benefit managers at the expense of shareholders? So this process suggests in a way that there's no uniform race. Delaware races toward the top, Nevada races toward the bottom. There's a market segmentation story, right? No uniform race, instead market segmentation, right? But is it good or is it bad, right? Does it suggest that the system is desirable or not? So I think here there are considerations that suggest that there is a problem. There are considerations that suggest that there are advantages to the system, and I can't tell you from these projects what the bottom line is. What it does suggest is that there is an option now for companies to be governed by no liability regime, right? And if it attracts companies that have high agency costs, then these are the companies that actually could benefit from regulation most, right? So we end up with a situation where the companies that could benefit most from regulation are the ones that opt for no regulation. And the companies that opt for strict law are the ones that already have strong shareholders, low agency costs, etc. And that's a reason for concern. In other words, if you heard before, there's a strong argument in favor of choice is the private ordering, right? Let companies sort, and this may suggest that the sorting is not necessarily efficient. That it's not necessarily that companies that should choose lax law choose lax law, and the opposite. And another reason for concern is that Nevada may be creating some pressure on Delaware. So this argument has been raised before. Roberto Romano has showed how Delaware adoption of takeover law was a response to other states' behavior. And it could be that Nevada pressure would drag Delaware down somewhat, or at least would prevent Delaware judges from becoming more and more pro-shareholder out of a concern that they may lose corporations to Nevada. On the other hand, as we've suggested, right, there is an advantage to the current system in the sense that it provides more information to investors. So when you have companies sort that way, right, investors can learn from that on the type of companies and why do they make these choices. And the last reason is that it's possible that it's also efficient for some companies to choose this lax law. So I don't have answers yet, but what I do have is maybe a somewhat broader implication of suggesting, which is I think that what Nevada case suggests to us is that we should start and look into the kind of companies that make different choices. Because in many other issues, companies make different choices. There are other choices to make other than the state of incorporation. For example, companies choose whether or not to adopt a poison pill, whether or not to adopt a staggered board, whether or not to adopt majority vote. And what the Nevada story suggests is that we should start researching and looking into what kind of companies are doing what. Because this is an important question that could have welfare implications. Thank you.